Well, let's switch quickly to our second issue for discussion tonight, and I'll be bringing on a senior advocate of Nigeria, President Muhammadu Buhari, and the Attorney General of the Federation, the Minister of Justice, Abubakar Malami, are filed a suit at the Supreme Court, seeking an interpretation of Section 8412 of the Electoral Act Amendment 2022. In the suit filed on April 29, the President and the AGF, who are the plaintiffs, listed the National Assembly and as the sole defendant. They are asking, seeking an order of the Apex Court to strike out a section of the Electoral Act saying it is inconsistent with the nation's constitution, according to the court document. The plaintiffs contended that Section 8412 of the Electoral Amendment Act 2022 is inconsistent with the provisions of Sections 42, 65, 66, 106, 107, 131, 137, 147, 151, 177, 182, 192, and 196 of the Constitution of the Federal Republic of Nigeria 1999 as amended, as well as Article 2 of the African Charter of Human and People's Rights. Meanwhile, the Federal High Court in Abuja today has fixed May 24 for the definite hearing in a suit instituted against President Muhammadu Buhari by the People's Democratic Party, PDP, on Section 8411 and subsection 12 of the Electoral Act. Justice Inyang Eko fixed the date today to enable the President and PDP to address the court on the effect of the judgment of the Court of Appeal in Abuja, which declared the contentious Section 8412 unconstitutional, null and void. Let's get some legal perspective, because this has really caused a lot of stir and debate within the political scene in Nigeria. I'm being joined tonight by a very senior lawyer in Nigeria, senior advocate of Nigeria, Jibrin Okutapa. Thank you so much for coming on tonight. I appreciate it.
Thank you, Shenwu, for dragging me here.
Thank you for always yielding, because where we need this kind of clarification, we need sound legal perspective. I know as of right, the Supreme Court on Section 1231, I guess, has given jurisdiction of the Apex Court as to the areas that the Supreme Court can adjudicate upon. Cases between state and state, cases between the federal government and state, cases between the National Assembly and the executive. For the case that the federal government, the President of Nigeria and the AGF had gone to the Supreme Court about, what's your view on that position, on their position and their suit they filed?
Well, Shenwu, let me confess that I'm a little bit constrained in being blunt. This is because the matter is in court. But as a Nigerian, I will want to find out, because I have not had the privilege of meeting either the President of the Federal Republic of Nigeria or the Honorable the Attorney General of the Federation, who are co-plaintiffs in that matter. But speaking for myself, when you look at Section 84, subsection 12 of the Electoral Act, which is in contention, that section of the law has nothing to do with the federal government or Federal Republic of Nigeria. That section talks about political office holders. I am not too sure that the President of the Federal Republic of Nigeria is a political appointee. He is an elected President of Nigeria. And I am also not sure that the office of the President of the Federal Republic of Nigeria is a political appointee within the meaning of Section 84, subsection 12 of the Electoral Act, to confer on that office and the office of the Attorney General of the Federation, to confer on them what in legal parlance is called local standing. Mark you, the Supreme Court of Nigeria, yes, has jurisdiction to determine dispute between federal government or Federal Republic of Nigeria and the National Assembly, where there is a justiciable dispute. And what is the dispute between the Federal Republic of Nigeria and the Office of the Attorney General of the Federation? Mark you, the President of the Federal Republic of Nigeria signed the bill. The National Assembly, in performance of their legislative functions, passed the bill and sent it to Mr. President, who assented to it. So I am finding it almost extremely difficult to see a justiciable dispute between the federal government and the Office of the Attorney General of the Federation. Now, we must make a distinction between the occupant of the Office of the Attorney General of the Federation, who is a political appointee, and the Office of the Attorney General of the Federation, which is a creation of Nigerian Constitution. So if it is the occupant of the Office of the Attorney General of the Federation that had filed this suit in the Supreme Court, then there is a further challenge that I see, because the additional jurisdiction of the Supreme Court, as given to it by the National Assembly and Section 233 or so thereabout, does not confer locus on the occupant of the Office of the Attorney General, who is a political appointee, to approach the Supreme Court. So the appropriate court, if the occupant of the Office of the Attorney General, who is a political appointee, wanted to engage in interpretation and want a judicial opinion on the matter, the appropriate forum would have either been the Federal High Court or the Federal High Court, not even either the Federal High Court. So what I'm struggling to see, therefore, is what is the locus of the President of the Federal Republic of Nigeria.
For the sake of our non-legally oriented viewers, locus is whether or not you have the grounds.
A grievances. Yes. There's something that affects you.
Do you have a ground?
Do you have does that section affect you
in any way?
In any way, as a government? Because when the Office of the President of the Federal Republic of Nigeria goes to court, is not going to court as President Muhammad Buhari, the occupant of that office. We must make a distinction between the Office of the President, the Office of the Governor, the Office of the Speaker, and the occupants of those offices. Section 84, subsection 12, talks about and affects political office holder. I don't have a copy with me, but if you have,
it's there on the screen.
So you may look at it.
Let's look at it again. Section 84, subsection 12. And that's it. Let me read it out for the sake of our viewers. No political appointee at
that
any
is the
level.
word. Political appointee. Who are political appointee? Ministers, commissioners, special advisors, and all of those people appointed politically. They are not elected government officials. The Attorney General of the Federation, as a person, is a political appointee. The Honorable Minister of Information and Culture is a political appointee. But the office of the Honorable Minister of Culture and Information and Culture is not a political appointee. President Muhammad Buhari is not a political appointee. He's an elected president of Nigeria. That section does not affect him. So the office of the President of the Federal Republic of Nigeria is not a political appointee for purposes of going to court to find out whether that section is unconstitutional. The only persons who have the local standard, the authority, the
grounds,
the complaint, those who can complain are those who are directly affected. That is why the judgments of the Federal High Court in Umuahia was set aside by the Court of Appeal, Abuja, because the person who went to court did not have the local standard to approach the court. But the question I ask Sheung is, why are political appointees afraid of challenging the law? Why do we use the color of our office to challenge the law when that office is not affected thereby? Look, Supreme Court of Nigeria is a serious court that should deal with serious constitutional matter. Supreme Court does not have jurisdiction to render advisory opinion. There must be a justiciable dispute, a dispute that is worthy of judicial consideration between the National Assembly and the President or the attorney represented by the Attorney General of the Federation, not the occupant of the office of the Attorney General, before the jurisdiction of the Supreme Court can be invoked. So, Supreme Court of Nigeria does not engage in determining academic question or hypothetical question or questions that have no live issues. So the president going to seeking interpretation of the unconstitutionality of section 84, subsection 12, when the president is not directly affected and when there is no dispute between even the National Assembly and the president, makes me wonder whether
Leonard Six, some will argue on this issue matter of locus that there is the restrictive, in the case of Adesanya, restrictive concept on the school of the locus, and the liberal concept of locus. In the case of Dr. Beko Ransom Kuti versus the Attorney General of the Federation, in the case of the Guardian newspaper, when he went to court, and said, the court said, you do not have the locus because you are not directly, he said, is in public interest. Could this be one of such cases that also plays within the realm of the liberal school of thought of the locus?
What is the public interest in section 84 subsection 12 that the federal government is going to seek on behalf of political appointees? Let's call a spade a spade. There are serious legal issues that the federal government and the office of the Attorney General should devote their attention to, not to go and bring an action that affects infinitesimal number of Nigerians. How many political appointees do we have in Nigeria? And how many of them nurture the ambition of running for office? Or how many of them indeed are elected delegates to participate in the affairs of the political parties?
It could be the interment of the position of the president and the Attorney General be that, look, there was an error ab initio before the president signed, and it clearly stated it out.
Before that, there was an error ab initio.
Yeah, it discovered that, look.
That error does not translate to a justiciable dispute because the president in the court of equity will be extolled from even complaining because he signed. If you open your eye widely and sign a law, an error that you see, can you then be turned back to say, oh, this law ought not to be there? Mark you, the president had rejected the signing of this bill initially. It was taken to the National Assembly. Then there were instructions of certain provisions in that constitution. The complaint then was that this your direct primary provisions is not going to work. Bring in indirect or consensus. And the National Assembly, in the performance of their legislative duty under the Constitution, went back, looked at the law, and did what they needed to do and passed the law. Now, the same National Assembly had, whether day before or last week or so, also done some amendment to the provisions of this Electoral Act in respect of the provisions of the Constitution, that act that says that before you can be a delegate, it must have to be by democratic means. That law was amended. Mark you also that there was an attempt or a letter sent to the National Assembly by the President of the Federal Republic of Nigeria seeking an amendment of that same section of the Electoral Act. And that bill or that proposal is still within the National Assembly. Except, of course, the President is saying that the failure of the National Assembly to accede to his request has constituted a justiciable dispute, for which, again, a question may be asked, is a refusal to make law a justiciable dispute to go to the Supreme Court between the Federation and the National Assembly within the intendment of the additional jurisdiction of the Supreme Court? All I am struggling to say is that their lordships at the Supreme Court have been overwhelmed and overburdened with some matters before them, that instead of these ventures, we should have improved on their working conditions, additional justices of that court appointed for Nigerians to get quicker justice in the court. I see this case going there as adding further burden because the law is that no matter how a matter looks, even if it looks very unnecessary, I don't want to use the word, the court must look at it.
All right. So we need to anchor now, and we need to do that in about 20 seconds. But in respect of this, the president had made a decision that, look, if you are in my cabinet and you are running for office, resign. Is this also about this fear?
So, if he says so, which means he's paying fidelity to Section 84, subsection 12. Can he now be said to go to court to ask for the interpretation of that provision?
Could it be because of posterity?
Which posterity? Let him leave the posterity. When anybody comes in future and he feels seriously affected by that provision, that individual, the point I'm making is that the office of the President of the Federal Republic of Nigeria is not affected by the provisions, and therefore you cannot manufacture a justiciable dispute to clothe the Supreme Court with jurisdiction. And I think that when our political class go to court, I pray that also they should make the working condition of our judiciary more conducive for other Nigerians, because there are more things that the government needs to do for other Nigerians to attain quick justice than this kind of political suit that so much, is intended to interfere with the quick dispensation of other cases.
All right. Senior Advocate of Nigeria, it's always a pleasure. The way you put things and clarify it is always putting things, laying them bare and getting perspective for Nigerians. Many thanks, Senior Advocate, for your industry tonight.
Thank you. I appreciate it. I wouldn't want to say that what somebody said yesterday to you, so your brain is still correct.
Thank you so much. I appreciate it.
Thank you.
For validating my brain. That's our show for today, everyone. Many thanks for watching. I'm sure Kimale. Bye for now.